Yes, there's no apologies and evenings.
And the answer is
Wait,
she's free falling.
Do I have someone here? Yes, Attorney Kingsley. Now calling 25C4201. This is Lakeview versus Valerie Barnes.
Good morning, Your Honor.
Okay, that intro was Zach's fault, and this is all Brecken's fault.
Brianna Kingsley for the plaintiff.
Thank you. Ms. Barnes, you need to unmute, please.
This is
Yes, this is Valerie Barnes.
Okay, thank you. So, Ms. Barnes, you came in late. You missed the advice of rights presentation.
Yes, I was trying to get up on here. I was on the wrong thing.
Okay, so I'm gonna have you stick around after we're done here and you can watch the presentation afterwards.
Okay.
Order is being adjourned to November 12th, 2025. That will be at 1:30 in the afternoon over Zoom in front of Judge Washington and
Why does she have two pairs of glasses on? Please, someone explain. I'm confused.
Attorney Kingsley the balance as you have it, please.
I have right to retain of $1,740.83, $175 in costs, for a total of $1,915.83.
Okay, so they added this month's on too?
Yes. If you
Okay, so
carry
that means I have to the end of this month then. Since they added that on, that's what legal aid told me. Whenever they add the month on, you have to the end of that month. So if they added November on, I have to the end of November?
Well, none of us can give you legal advice. You'd need to talk to legal services again. Okay.
Uh-huh.
All right. You do have a court date next week. All right.
Okay.
So it'll be at 1:30. Did you want to talk
You have pretty much exactly the amount of time that the judge gives you. No more, no less.
to the court liaison?
Yes.
Okay. So
And now, but the one that they gave me, it was for $1,004 was for the one that I was supposed to pay for last month.
okay.
Your Honor,
So-
that would have been the complaint. The complaint was filed last month, so yeah, the balance includes November.
Okay, now are they adding another 175 for another legal filing fee again?
No.
Okay, because they always do. Okay, so they are okay.
So I'm going to send you an invitation to go into.
See, here's how they do it. They add a filing fee when they incur a filing fee. That's it. There's no mystery.
The breakout room.
Okay.
Just wait to speak with the court liaison and then come back out when you're done.
Okay.
Now calling 25C4210. This is Lakeview versus Shahil Mujahid.
Brianna Kingsley for the plaintiff.
yes,
Thank you. State your name, sir.
Shahid Shabazz Mujahid.
Okay, thank you. And I'm sorry, it looks like they have an L in your first name for some reason. So it's just Shahid?
Yes, ma'am. Yes, Your Honor.
Okay, thank you. All right. And did you have any questions about the advice of rights presentation?
No, I didn't. However, I wanted to ask. Yesterday I attempted to pay October, the last month's rent. Is it last month, October, right? The last month's rent. However, it said that I was only able to pay a minimum amount, which included this month's rent. And so I'm trying to figure out how can I rectify this affair. They don't accept partial payments. I don't know. I want to rectify the affair. However, I just need to work some arrangements out. it doesn't appear they allow for that with regards to the policies and procedures.
Okay, so none of us here can give you legal advice. I will say that if you wanted to have a conversation with someone from the attorney's office, that their contact information is on your court paperwork. All right. Attorney Kingsley, I don't know if you have anything to add about.
I do know that their software system online does not allow for partial payments, and I don't believe that they accept partial payments anyway, so a money order or cashier's check for the full balance would need to be dropped off.
Well, I'm saying, but even I'm not saying a partial. I was prepared to pay.
Yeah, go ahead and pay it all. Or pound sand. That's our position. I don't know if that's the best play, but they might have to with the way the sort of collection law is. I don't know. It's kind of funny though. No, that's not a bug. That's a feature.
Pay the entire rent for that month. That was
Right,
late.
but but November had already.
They're obliging me to pay 2 months at one time, and I don't know if I mean, so
Yeah, see, here's the thing. That's what you owe. And they want it all. Not some of their cash. Oh no, but all their money.
that I'm just not able to do that. I can't pay I can't pay 2 months rent at one time.
How about
So
I
I'm trying. I want to cooperate. I'm trying to figure out. I mean, I'm not being given any options, or can we work? I mean, how can we rectify the affair?
couple of things. So again, us can give you legal advice.
You could pay all of it. I get it. I get why he's frustrated because if what he's saying is true, and I believe it is, he in good faith is trying to catch up. I'm laughing at it because it's funny, but I do think his heart's in the right place. I could be wrong. I get it. But those are the rules. And they may have them for good reasons. But it's not for the judge to explain it to you.
I can put you into the breakout room with the court liaison so that you can talk to her about what some of the resources are that are available for you. All right.
Well, I'm saying options. I just don't understand what's going on. I mean, what are my options? Who can I speak with? I mean, I don't know. I'm just trying to figure out what to do here.
So in with your court paperwork, like I said at the beginning, you should have.
If you call a collection firm and say, I've got money, I want to give it to you, they'll pick up the phone. That's kind of their whole raison d'etre, that's what they do. And if they can accommodate it, they will. And I'll tell you why, because they get a piece of it.
Gotten that form that says get help with your eviction in big bold letters at the top. Do you have that?
Oh, I'm just, yes, I have this. Get help with your eviction.
So yes. So
Never mind. It was my bad French. Don't worry about it.
the first bit of contact information on that on the left-hand side should be Legal Services of South Central Michigan. Okay. So you can call them to set up a consultation to talk to them about the situation, because it sounds like some of what you're asking is legal advice. None of us here can give you legal advice. Okay. That's not my role.
No, I'm asking just procedural advice with regards to, the policies of the institution.
Thank you
that
for
I
that
owe.
endorsement.
I mean, is it? They appear to just. It appears to be very rigid. Perhaps I need. I'm not understanding.
So again, some of these are questions that
Good.
you're not going to get answered here today while you're
Okay.
in court.
Is there a representative from Lakeview available to speak with about? I thought that this court hearing was that I would face them and we can kind of talk about what's going on so that we can arrange make some arrangements. So my family's not going to be out on the streets. This is what I'm here for. I want to cooperate. I'm not trying to.
So I'm going to have you talk to the court liaison.
Wait a second. You're saying now that you want to pay your rent so you don't end up homeless. It's a fascinating concept. It's one that, most of us live by. And I understand it. And I think you're trying. I do. But you don't need to announce this something that obvious in court. You just don't.
All right.
Okay, listen, can I run to the restroom really quick because I've been waiting for a long time and I didn't want to miss my appointment. Can I come to? I'm actually at work right now, but I need to run to the restroom and come right back.
Okay.
Can I do that?
Yeah, I'm gonna send
Okay,
you.
so well, what about?
Just take your camera with you. We want to know where you are at all times.
Is it going to be a? Am I scheduled for another? I heard other people that have been scheduled for another appointment. Is that my case or what's? I don't. What's
Okay.
the next step here?
November 12th, next Wednesday.
Okay,
At
what? Why is that?
That's how this process works. Everybody gets a second court date. It's in front of the judge.
Okay, and what will that be for?
That will be to resolve the case one way or another. Okay, so
Okay.
we'll have,
Well, again, what do I do to that up to that point?
okay, that's a
With
question.
regards to trying to make some, I mean, I tried to make a payment.
Did I hear right? Did he just drop a what that be for? Or is that me? Please tell me I heard that wrong.
Who do I
Sir?
talk to? Yes, ma'am.
Okay, so just let me finish real quick,
Okay.
and then I'll send you into the breakout room to talk to the court liaison. So
Okay. Can I run to the restroom, please, Your Honor?
Well, just 1:30 p.m. And what's the balance, Attorney Kingsley?
Rent to retain is $2,500.43, $175 in court costs, for a total of $26.75 and 43 cents.
Okay, thank you. So I'm going to send you the invitation to go into the breakout room, and then yes, you may go use the restroom. Thank you.
Okay, so when is my next court date here?
November 12th at 1:30 over Zoom.
Okay, will they send me some information documenting that so I can show my principal here, my employee?
Yes.
Thank you very much, Your Honor.
Okay, you're very welcome.
The word you were looking for was employer.
You should have that invitation to go into the breakout room.
Okay, thank you.
Thank you.
Painful.
All right, I'm going to take up the matter of Butler versus Butler. All right, Mr. Butler has filed a motion to alter or amend the judgment in this case. And Mr. Butler, this is your motion, so I'll be glad to hear you.
Yes, sir.
Come to the podium.
Yes, sir. It's hard to remember. I'm currently incarcerated right now and trying to remember
we see that.
everything since I've had no time to really prepare since this. I've also filed a motion for mistrial, and is that part of this too? Or-
I have a motion to alter or amend, and I then have
Sorry.
so I'm giving you an opportunity to
I'm feeling the moat point coming on here.
address all of the issues that you have raised in your motion to alter or amend. Do you not have a copy of it?
I'm not with me, no, sir, because I'm incarcerated right now due to being targeted.
Let me tell you.
Yeah, we know. Our first clue was the outfit. You know, that kind of unless, since Halloween's passed, maybe if it was a couple days ago, you're just dressing up as someone who's incarcerated. But right now, it's very convincing that you are, in fact, incarcerated.
What you said in your motion says that you're filing this motion pro se pursuant to rules of civil procedure 59.04 to alter or amend the final judgment in the following basis. You allege the final hearing was held in the matter on July 14th, 2025 and July 15th, 2025. The court's judgment is based on erroneous findings of fact and the fundamental failure of due process, which constitutes a manifest injustice. And do you want to address that issue and what it is that you're saying occurred that
Yeah, the illegal ex parte meeting that happened during the trial that happened. And then also, I think it was $800 a month I was supposed to pay in child support. And that was based on her income. And I do remember you specifically saying that the child support should not be based on her income due to me. I was laid off from my job, and I wasn't looking for a job because I am, and I've never made as much money as she has.
Well, I want to address
Yeah. Yeah. Sounds like you need to file a motion.
that second statement you made. Paragraph 3 of your motion states, the court engaged in improper ex parte communication. During respondent's cross-examination of the petitioner on July 14, 2025, the presiding judge, the petitioner, and the petitioner's attorney exited the courtroom and held a private meeting in the judge's chambers. The respondent was excluded from this meeting, which violated his fundamental right to due process in the Tennessee Code of Judicial Conduct, Rule 2.9.
Yes, sir, that did happen.
You're alleging that I had a communication with the attorney for the petitioner and the petitioner and about your case?
I'm not exactly sure what happened. I just know that.
Well, you've made an allegation,
That-
which I consider to be a very serious allegation.
Sure.
And when I'm talking, just wait for me to finish. So I want to know what proof you have that such a meeting took place, because I can tell you it did not. But I want to hear what evidence you have that you would have placed in such a motion.
So the only evidence I have is that when we were here, and I was actually questioning Mrs. Butler, that all of a sudden Miss Margaret got up and then she got up, and I noticed that you three went through that door, and then I was just left standing here. I didn't know what to do, so I went back and I sat where that man in the blue shirt is right there. I went back and sat right there for about 10 minutes. Miss Butler exited that door. And then about 5 minutes after Miss Butler came out, Miss Margaret came out, and then you came out. I don't know what you guys said. I just know that.
So
That
you have
happened.
no evidence that any such so-called meeting occurred between me and Miss Brady and the petitioner in this case. You're just assuming that such a meeting occurred because we left the courtroom at the same time. Is that
I
correct?
just don't know what else would have happened. I did file for a mistrial first.
Yeah, that's not working.
And I don't know why that didn't come through.
Look at Judge Wolf's expression. It was fantastic.
But I do know that I wasn't getting dates while I was filing stuff.
Judges are generally, and certainly Judge Wolf is aware of ex parte communications and when they're appropriate and when they aren't. I assure you, he wasn't doing anything he wasn't supposed to do.
So I tried to, did the mistrial first to make things. I don't know if it would make it right better or, I'm just trying to do the best I can, Your Honor. I lost my son. I was doing everything right. Like the courts asked me to take a drug test. I passed it. I didn't get my son. I lost my son on false allegations of drug use. And did everything the courts asked me to do. I still didn't get my son back. I lost everything, Your Honor. I lost literally everything. And I've had the Cheatham County Police, they've targeted me, and I've got evidence of that. And it's just, look at me.
Paragraph 4, you allege that the petitioner provided false testimony under oath regarding allegations of domestic violence, which the court relied upon in its ruling. You vehemently deny the allegation that you jammed your thumbs into the petitioner's eyes or punched her. Basically, you're saying that I relied upon false testimony, but I heard both sides of that testimony. Well, I heard her testimony, and I think you were pending criminal charges at the time, correct?
Yes, sir.
Okay. The paragraph 5, the court's judgment relies on a pattern of false allegations. Prior to the final hearing, the petitioner filed an ex parte motion to suspend your parenting time based on claims of drug use and unsafe home. Those claims were investigated by the Department of Children's Services and were proven false. Furthermore, you passed a court-acknowledged 10-panel hair follicle drug test. Anything you want to add to that? I'm considering your motion, so I'm giving you an opportunity to
Yes, sir.
provide me with any kind of proof regarding your allegations.
There was also there's the allegations that I was homeless, and then they came and inspected my house as well, and did a home visit, and she saw I lived in a beautiful home. I was very stable, and after that, Judge Turnbow, I didn't get to get back in front of him because he went, they go, I guess y'all guys alternate. So I filed another motion and I was running late to court that day due to my car issue. And I've since filed a motion for that. And, but I called as quickly as I could, and the lady said that your case had already been heard and they're not going to do anything. And I was just devastated. I was just like, because I thought that would be the day I get my son back.
All right. Paragraph 6, the allegation of harassment at the ninja class is further evidence of this pattern. The petitioner obtained an order of protection based on claims of harassment and threats. The incident did not occur. Class was held in a small room filled with numerous parents and children. No independent witnesses came forward to support the petitioner's story because it did not happen. Paragraph 7, the petitioner's attorney made false representations to the court. The respondent inadvertently sent a draft email with no threats to attorney Margaret Brady. Attorney Brady then falsely told individuals in the courtroom that the email contained threats and a deliberate attempt to poison the proceeding. So you have filed a motion making these allegations, and today is your day to show to the court the basis for any of those allegations.
Sure. So for the ninja class, it was worded in such a way that I so happily showed up there. And I feel like the way that things were worded to obtain this no contact order, it was specifically for that and for that only. And just before that
Yeah, we don't care about your feelings.
incident, or there really was no incident, I was trying to break contact off of Miss Butler because of just how angry she was. And I just wanted to support my son. I've been there since day one supporting my son. And for whatever reason, these people just come out of nowhere and just don't want me in his life. And that's exactly what has happened. And then there was no need for a no contact order. There was no need for that at all. And it was there strategically to violate me 100%. And it was malicious, if you ask me. That's how I feel. I don't have anything with me right now, but and then also my probation was violated at the wrong place at the wrong time, and I'm fighting those charges and more than likely will win. And Miss Brady, before the proceeding of the violation, was telling the courtroom that I have a draft email, and for whatever reason, it was addressed to her, and it was nothing of the sort of threatening. And Miss Brady was talking about it in the courtroom the day before my violation was set to be heard. And my attorney said, "Where's this threatening email?" And I gave it to him. I said, "Here." And there was nothing in there threatening. So for whatever reason, I felt like she was trying to poison the well before it even got started. Because, you know, her sister-in-law does work down there.
All right. Have a seat at the table. Ms. Brady, do you want to respond to the motion to alter or amend the judgment?
Your Honor, we would just say that,
You'll come to the podium so
Sure.
let's pick up.
sorry.
Obviously, we would say there's no ex parte communication with the court, but all the other things that he mentioned in his motion are based on witness testimony, and the court had that opportunity to hear that then and deemed Ms. Butler's version of events to be credible and made a ruling based on that. And we would say that there's no grounds for to alter or amend this judgment put forth by Mr. Butler today, and we'd ask that be dismissed and this be considered a final order.
Number one, the court specifically will address the allegation that the court engaged in an improper ex parte communication. Mr. Butler has affirmed on the record that he has no evidence of such a meeting occurring, other than the fact that circumstantially Ms. Butler and her attorney, Ms. Brady, exited the courtroom, and that I exited the courtroom at the same time. That alleged meeting did not occur. There was no ex parte communication between me and Ms. Brady and Ms. Butler. And I specifically find that that allegation was made without any evidence and with nothing more than circumstantial belief by Mr. Butler that somehow something was being done inappropriately. So I find that that basis is a false allegation regarding the behavior of this court and that of Mrs. Brady as the attorney for Ms. Butler. In addition to that, all of the other, as Ms. Brady has pointed out, all of the other allegations that he makes are all basically complaints regarding the court's findings at an evidentiary hearing. And the court finds that the testimony that was offered at that hearing was the basis for the court's order that was entered, the final hearing order. And that final hearing order was filed September the 2nd, 2025, which was after his motion to alter or amend. And that hearing order was based upon the facts as were presented in this court at the final hearing, where Mr. Butler was present and given an opportunity to participate. And that as a result of that, no evidence has been brought forward to satisfy the court that there's any basis for an alteration or amendment to the court's prior order. Therefore, his motion to alter or amend the judgment filed August 25th of 2025 is overruled. Then there are some additional motions that have been filed, and I would like to address those motions, and Ms. Brady, unless you need additional time to consider them. He has filed on October the 1st a motion to reconsider and amend the final order as to child support.
Which might not be the top of your list. I filed a motion to dismiss all of the remaining motion and for sanction. And so if we have argument on my motion to dismiss, it might resolve those motions. Might be a way to handle it. Probably won't be able to proceed.
We'll consider your motion to dismiss, considering and consider that before we take up any of these other motions, because if your motion is valid, then it will not be necessary to consider those additional motions.
Your Honor, so the other motions were not, as you know, set on the docket today, but I wanted to bring them all up before the court today so we could just deal with this all together. So as you can see, I filed a motion to dismiss. He has additionally the motion to reconsider and amend as to child support, an emergency motion to reinstate parenting time, and for immediate hearing, a motion for mistrial. There was a motion for personal items that's already been dismissed by Judge Turnbow because for failure to prosecute. So on these remaining motions, Your Honor, I would say that these are going to fall kind of in the same lump as the motion to alter or amend. They're all based upon problems that Mr. Butler has with testimony that the court considered that he had an opportunity to cross-examine and participate in that hearing. And we would ask that all of those be dismissed. And furthermore, Your Honor, we've also asked for sanctions pursuant to Rule 11.02. And specifically, Ms. Butler is asking that she be reimbursed for her attorney's fees to defend this motion today. As we know, there's been a history of harassment and stalking and domestic assault. And now that Mr. Butler is unable to do that out on the street, he's using this court to continue this harassment because he's dissatisfied with the court's ruling. And he has had no basis for these motions. And so we would ask that he be responsible for attorney's fees today. Additionally, though this was very late filed, and I'll acknowledge that, I filed a motion to relocate, and also we're having a problem selling the house. I understand if Mr. Butler doesn't want to deal with that today, he has that right. But you had asked that if we can't get the house sold at list price, that we need to come back and talk to you about that. And they've had one showing the whole time that it's been on the market with no movement. And we're asking that if the court will hear that today, that we be allowed to accept the reasonable recommendation of Amanda Bell, who is the realtor, and just try to get this house sold. But I understand if that needs to be reset.
When you say I had asked you to come back and talk to me, you were talking about having come back to court on that issue.
Yes, Your Honor. So in our final hearing or final decree, you had said if she's not able to sell it at list price, that we needed to get permission from the court to reduce that price so that there was a basis for it. And if you need to hear from Ms. Butler, we can do that to
Well,
describe
you
that.
just filed it yesterday,
Yes.
so I'm not going to require Mr. Butler to have a hearing on that particular issue because of the fact that it's not, he's entitled to 5 days notice prior to that. We can set it later in this month for a hearing, but
Okay.
it would not have to be, it would not be fair to him to have a hearing today with a motion filed yesterday.
I understand.
Mr. Butler, did you raise your hand? Do you have something you wish to say?
Yes, sir. The house is listed way too high. It's listed at like almost
I'm up to the
400,000.
podium.
She has the house listed way too high. It's at 400,000. It's not worth that much. I understand that the market value has fluctuated these last few years, but it was nowhere close to that. And then also with the motion for emergency custody was because I satisfied everything the court needed me to do. But right now I'm incarcerated right now with no probable cause. So, you know, that's why I can't keep up with everything. And a lot of this is not based on, so I don't know. I've lost everything. I lost my son. I've lost literally everything for nothing. And they just want to take more and more and more and more. I can't even afford a lawyer, but I got to pay for her lawyer fee. And then they got the house marked up way too hot. And then, Your Honor, I just really hope you'll take into consideration that, you know, a lot of this was done and I have been targeted by the Cheatham County Sheriff's Office. They violated my probation the first time based on words. And then, I've got proof of it. I've got proof of it. And a lot of it came from her. And I just really hope you'll take that into consideration, Your Honor. I mean, I've been a good parent. I'm a supportive parent. I've worked our entire marriage. I've worked until I lost my job. And then on top of that, I didn't just sit there. I went out and I made money. It wasn't, you know, a bum. I did what I could for my son. I went from being that dad every day with my son to nothing. And they just took everything out of my life. I'm in jail right now for nothing because they targeted me because she could win 100%.
All right, you have also, and Ms. Brady, I'm going to go ahead and consider these other motions on the record because it's my understanding he's filed an appeal. Is that correct? He's filed a notice of appeal to the Court of Civil Appeals, and therefore I think that all of these motions need to be addressed that he has raised regarding the final hearing. So the next motion that I'm going to take up is an emergency motion to reinstate parenting time for immediate hearing. Mr. Butler, you have filed a motion to reinstate your parenting time.
Yes, sir. I did. That was before I was on private property and the Cheatham County Sheriff's Office came up and arrested me for being on private property. And now I'm here. And so if I were to win this, I guess I couldn't get it anyway because I'm incarcerated. But so I don't know if maybe when I get out, if you were to give it to me. But Miss Butler's whole goal was to move back to East Tennessee, where she was from. That's why this, you know, the no contact order for no reason came into play. And that's why a lot of this is like the whole targeting thing is like so aggressive is so that way she can move back to East Tennessee. 5 hours away. I mean, no, not that I'm a bad dad, not that, you know, I'm out partying, I'm out doing drugs, nothing. It's just bullshit. And they've got me hemmed up. I mean, it's hard when you're a small guy. You got no lawyer. I did have a lawyer. She withdrew from my case because of Margaret Brady. I've got her on tape saying that. She doesn't want to go against Margaret Brady. She's took all my money, so I had no money left, so I had to defend myself, and I still lost fucking everything. I mean, I've lost everything, Your Honor. I'm sorry. I'm not. It's just, I mean, I'm a good dad that's fighting to be with his son, and I just keep getting shot in the foot. It's pretty bad. It's pretty.
All right. Your motion to reinstate parenting time and for immediate hearing is going to be denied simply because of the fact that you're incarcerated. I'm not going to reinstate parenting time because you are incarcerated, but the final order in this case provided that upon your release from jail, that you would have the right to exercise supervised visitation every other Saturday and Sunday from 9 a.m. to 5 p.m. each day with no overnights. That would be supervised by a third party agreed upon by the parties. That you would be permitted to petition the court for review of your parenting time after your criminal charges were resolved without the necessity of showing a material change of circumstances. I don't know how it could be any more fair with you in the situation that you're in. All of your argument has to do with how unfair you think it is that you're incarcerated. That's not an issue before this court. The fact of the matter is you are incarcerated.
You're right.
And because of that fact, you're not going to have visitation with your minor child or children until you are resolved of that. And this final order that I put down provides a method by which you can have visitation, and you can even have it reviewed after all your criminal matters are resolved to try to reinstate some sort of a normal visitation. So your motion to reinstate and your visitation immediately is denied based upon the fact that there is provision in the order for that to take place. The next motion that you have is a motion for a mistrial, and I will just simply, I don't even need to hear any argument. Your motion for a mistrial is based upon paragraph 1, ex parte communication, July 14th, 2025, during the final hearing in this matter, the presiding judge, Judge Wolf, plaintiff Aaron Butler, and plaintiff's counsel Margaret Brady left the courtroom together and entered into the judge's chambers for approximately 20 minutes. Defendant Robert Butler was not invited nor informed of the content of the discussions and was not given an opportunity to respond. The ex parte communication deprived the defendant of due process. I've already addressed that issue with you. You have affirmed on the record that you have no evidence of any such meeting occurring, that it was all circumstantial because I left through this door to my right, they left through the door to my left, and as a result, during a recess of this court, that you assumed that there was some sort of ex parte communication. I affirm on the record that no such communication took place and no such meeting took place, and that allegation was based upon a false statement by you. Therefore, your motion for a mistrial is denied. All of the rest of this, of your motion for a mistrial, which is not appropriate after the final, you don't file a mistrial motion after the case is concluded. And for that reason, in addition to the fact that I've considered all of the other bases, and there is no basis for a mistrial to be granted after the entry of the final order in this case. The last motion is a motion to reconsider and amend the final order as to child support. And at that point in time, I found that the mother's income was set at $6,000 a month in the final hearing, that your income was imputed even though you were in jail pursuant to the rules of the child support guidelines, simply because of the fact that if you were unemployed, it was due to your own fault. As a result of that, you could have the imputed income that the child support guidelines provide. I applied that to the calculation of child support, and therefore you're not entitled to an amendment as to the calculation of child support. That concludes all of the motions that are set, other than the motion to relocate, which was filed yesterday. I will not consider that until he's been given appropriate notice, an opportunity, and that would be later in the month that we have a chancery day we can set it.
Your Honor, I know that we're not taking up the motion for reducing the price of the home either, but since Mr. Butler seems to be on the same page as that, you think that we could consider that so that we can get that house sold and they can get some funds?
If he's willing to do it, we can. I mean, if he's willing to waive the 5 days notice and have it heard, yes. Mr. Butler, the rules of civil procedure provide that you're entitled to 5 days notice prior to the hearing on a motion that's been filed. They filed their motion to reduce the value of the property and to accept an offer less than the listing price. yesterday. So therefore, you have the right to object to that, and I'll have it set later in the month, or you can agree to hear it today, and then we'll put on the proof, let them put on the proof about why they need to accept this offer. Do you understand all that?
I understand it all. I guess it just depends on how much they want to reduce the price. If she wants to me and her work out a deal or something, I might be willing to talk about it for a minute.
Go ahead and have a seat over here, Mr. Butler. I'm gonna let Miss Brady talk with you, and we'll come back to you. All right.
Will be on the record on Rihanna Johnson, BU
This is Casey Smokey's fault.
2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, Jared Regier for the state. Rihanna Ray Johnson, that's you appearing in person in pro se.
Yes, ma'am.
Ms. Johnson, you're charged with count 1, driving while suspended, a B misdemeanor. You're charged with driving without proof of insurance, a B misdemeanor. Well, may I correct that on number 2, you're charged with driving without insurance after a prior conviction for driving without insurance in 3 years. That prior elevates it to an A misdemeanor. You could be looking at a minimum fine of $800 up to $1,000, and you could be looking at up to a year in the county jail. How do you wish to proceed on the issue of an attorney? Do you wish to have an attorney, or?
Yes, I would like to get a court-appointed attorney.
All right. Are you employed at this time?
My what?
Are you employed? Do you have a job?
Yes, I do.
Where do you work?
Premium Retail Services.
What do you get paid per month?
It varies, but I average probably like 30 hours, about 25 to 30 hours.
What do you make per month?
I make $13.50. Oh, I mean, $13.50 an hour.
You make $13.50 an hour at 30 hours a week. Is that what you just said?
Yeah.
But you don't know how much you make per month.
Well, it varies so much, but I average it out to be about 30. So
Are you saying about $405 a month? Does that sound right?
I'd say it's probably a little more, like about 600.
All right. And what do you pay for? Are you married or single?
Single.
Do you pay rent?
Well, that wouldn't be per month. That would be that's a week. Like so that would be
about $2,400 roughly.
Yeah.
You're saying $600 a month?
No, not a month. No. That's why I was like, wait a minute. Yes, I pay rent and electricity.
Tell me the amount.
600. 600 in rent. I don't know on the other because I just moved in, so I'm guessing maybe like 200 in electric and 100 in gas, maybe.
Any other expenses?
I have a cell phone. My child support.
Well, you
My
have
cell
to tell
phone
me
is-
the amounts.
My cell phone is like $240 because I pay for my kids' phones.
Okay,
and
but you don't have to, hold on, you don't have to pay for your kids. How much is yours?
How much is mine? Mine is like 120, I believe, because I have internet with it.
Okay. And you said some other figure, what was it?
I have child support.
Do you pay that child support?
It is like $370 something a month.
Do you pay that or receive it?
No, I pay that.
But you're not sure exactly how much?
I think it's like $167 per check.
What else do you have, if anything? Car payments?
No car payments. Insurance, I don't have that yet because I'm not driving. but I have to get an SR 22, so it'll be quite a bit. But I don't know what else
that's gonna be.
what else you claim. I don't know.
But you don't know what your car insurance is gonna be. You haven't talked to anybody about that? For your
Yeah,
SR?
it's pretty high. It's going to be like $190 for liability on my car, and that's a month.
You said child support. How many children are you supporting?
3.
So your family of 4. All right, I'll find you qualify and appoint attorney Darren Patterson. Have you taken down his number yet?
No.
Darren Patterson, Darren Patterson. His number is
Okay.
316-322-7700. Call him today. That's an order. Come back with him ready to go. And the next court date for Darren is when?
Your Honor, that is January 12th.
January 12th, 8 a.m. You have to be back.
I didn't catch that because somebody else was talking. What was that?
Well, it's January 12th, 8 a.m. You have to be back here by Zoom, ready to go with Mr. Patterson.
Okay.
And Your Honor,
Mr. Aguirre.
some new information has been brought to my attention recently regarding this matter. If I may request a brief 2-minute recess.
Granted.
Thank you, Your Honor.
2-minute recess. You're welcome.
Uh-oh. I don't know what that is. But it can't be good.
Thank you, Your Honor.
You're welcome. Back on the record in BU 2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, all parties as before. Anything further, Mr. Aguirre?
Merely that the state wishes to be heard on the issue of bond at the appropriate time if the court is making such an order.
This is the appropriate time. Please proceed.
Your Honor, in addition to the 2 charges currently before the court, both of which the state considers considerable, especially in light of count 2 being charged as a Class A misdemeanor, the state is recommending a bond of at the very least $3,500. The state does not oppose the court ordering an OR bond, given that the defendant appears in the fashion that she does today. Besides the charges currently before the court, the state understands this is a defendant with at least 1 prior driver's license violation, a diversion for DUI, as well as at least 1 non-traffic felony conviction. Under those circumstances, the state does respectfully submit that $3,500 is appropriate.
I have a question.
Go ahead.
On that, the DUI, I haven't received a DUI. I don't believe I've received one. When did they say I had a DUI on that?
I didn't hear a date or time. I can look and see what I have.
Regier won't even respond to
The
it.
record you have that I see for Odyssey starts with speeding in 2004, and then it jumps up to 2000. Well, that's a different kind of matter. You have a 2013 criminal for damage to property, interference with Leo, law enforcement. But it looks like the conviction was for criminal threat.
Yeah. I knew that. That's been like 12 years ago. But I don't recall ever getting a DUI.
Well, I'm looking for that. In the meantime, Mr. Regier, what year do you show that for her benefit?
Your Honor, in response to the court's inquiry, it does appear to be somewhat dated. Nevertheless, given the nature of the offense, the state does consider it relevant for purposes of setting an appropriate bond in this matter.
And when was it dated, you said?
I don't see it on her Odyssey, so it may not have been in Kansas, but how long ago was that? You said somewhat.
Approximately 20 years by the state's understanding, Your Honor, per the court's inquiry.
20 years. 20 years. So I don't even recall ever getting one 20 years ago, but so you bring up something for 20 years ago?
He sure did. That's what he did. He's Regier. And that's why we like him.
Yeah.
I mean, I don't recall ever getting a DUI 20 years ago.
No, I don't see it on your record. I'm not going to consider it, but for all the other reasons
Thank you.
stated, 3,500 OR sounds reasonable, and I am going to make that your bond.
And why is that? Just because I have.
Well, because you have a lengthy record, ma'am, from starting in 2004 up current, keeping it up till now. 2013. Do you want me to go into all of these? The criminal.
I mean,
charges,
I don't have
criminal charges.
But that's been like 12 years ago and has nothing to do with my driving, like record.
Well, your record has something to do with your record.
That's one felony. That's all I have on that. Like, I mean, I'm not trying to argue with it, but I don't have a really extensive record except for a couple driving on suspendeds. Like, I mean, I really don't.
Well, I'm giving you an OR bond. That means you don't have to put the money up, and I'm not going to go there's not much less I can do on that. I could say, 500 OR, and I'm not going to do that. You've got a long record here of different kinds of activities indicating to this court that you could be a flight risk. And so your bond is set at 3,500 OR. You may not like that. You may not approve of that. If you find yourself some kind of appeal, you can try that. But that's your record at this time. That's your charge at this time, and that's what You've also had a failure to appear in this case, Miss Knoxted. You failed to appear April 23rd. In this case,
not this one, because I just got this 2 months ago.
My apologies. I was looking at Knoxted's, and you're Miss Johnson. Let me look at that again.
Yeah, because I'm like, I'm not.
Okay, let me double check your screen. That makes a lot of difference. It actually makes it worse, because now you've got driving while suspended. Okay, you are Rihanna Ray Johnson, correct?
Correct.
You have driving while suspended and driving without proof of liability insurance after a prior conviction of driving without insurance within the last 3 years. So you've got an A misdemeanor, a B misdemeanor.
Mm-hmm.
And you've had Mr. Patterson, but you apparently didn't go over and contact him like I told you to.
To who?
Darren Patterson. Are you saying
I haven't done it yet because you just now told me to today.
All right.
I mean, I'm still in court, so I can't call while I'm in court, right?
Right. Now, Miss Johnson, you better calm down, because you're not going to do yourself any favors here. But here's your record. Going back to your record, 2004, there's speeding.
Mm-hmm.
There's some children involved in some cases that I won't use.
But that's irrelevant with this.
All right,
I mean,
look. Okay, are you going to let me be the judge and tell you what's relevant and what's not, or are you going to just take over the case? You want me to give over and let you want the case? I'm not.
No, but you don't have to be rude to me. I mean, but I don't know what my children have to do with me driving on suspended.
I'm not going to stand here and let you or sit here.
Oh, no, she didn't. Oh, Jerry.
here and let you talk down to me like that when you're the one that's accused of violating the law. And then you come in here with an attitude trying to tell me how it's going to be.
No.
Stop.
No,
Ms.
but you're
Johnson,
bringing my
stop.
children into it for why? My children have nothing to do with me driving on suspended. They have
Oh, I
nothing to
think
do with
they
that.
do.
None of them cases do.
All right, your objection is noted, overruled. Now then.
Okay,
you've got-
I'll just come back with my attorney.
All right, are you hiring your attorney or are you applying for your court-appointed attorney?
I'm applying for the court-appointed one like I had asked prior.
All right, and you're going to go over and you're going to talk to Mr. Patterson. And I suspect the first thing he's going to tell you to do is show some respect for the court, whoever the court is. You don't have to feel respect for me, but you have to show respect for the
I am showing respect, but you're being disrespectful to me. Like, I feel like you're being very disrespectful to me.
Oh,
Now
no.
let's finish looking at this record. I've told you, you want me to make it a cash or surety bond? Because you're starting to show me an attitude that I don't know that you respect the court enough to follow the court's orders.
I do respect the court.
You just don't respect me personally. Is that what you're saying?
No, I do respect everybody. I respect the court, but I feel like I'm not being respected at all. And I'm not being disrespectful. I really am not. I'm just saying that when I...
Yeah, you are. Yeah, you are. Oh, this is good. This is good. We get to have her speak for herself before Darren Patterson comes in and fixes it. He's gonna start that first appearance with, my client's a knucklehead. She was talking without me. It didn't work out well. Now I've figured out a good resolution with the prosecutor. Can we get that done, Judge? That's how that appearance is going to go down.
To like some of the things that you were saying. That's all I was saying. But I will keep my mouth shut and you can proceed and I will come back with my attorney, like court-appointed attorney. I apologize.
May I speak? And I'm being sarcastic and I shouldn't be. That's out of order. And I correct that. But you are provoking the court, Ms. Johnson, and you need to stop it. Now, pending, besides the case you have in front of me right now, you are charged with Sedgwick County District Court. You are charged in 2024 driving while suspended. That's still open. You've got a Harvey County case, driving while your license is canceled, suspended or revoked, driving without insurance. Familiar? That's what you're looking at in Butler County.
I just actually found out about those two cases today when I called to see where my court was today, because I didn't know about the one that I didn't know I had two open cases and one in Harvey. It's because I owe fines to it. That's it. And then the one in Wichita, Central County, I owe fines to it. That's the only reason they're open is because I still owe my fines. That's it. And I need to pay my fines.
So in addition to driving while suspended and driving without insurance after a prior conviction with 3 years, you have an open Harvey County case in addition to the Butler County one. Then you have the Greenwood, a limited case in Greenwood. You have a BU, that's Butler County, another, let me see, maybe that's, okay, that's the one here today. Yep. I have other things. 21 CR, criminal use of a financial card, theft of property. I'm sure you're going to tell me those have nothing to do with your traffic. But it tells me that you don't follow the rules, you don't follow the laws. Here's a traffic in 2018, speeding, operating without a valid license. 2015, driving without liability insurance. More civil matters.
And I have a question whenever you're done.
I'm not done. I've got to get past some of these matters. What county, Mr. Aguirre? I can't think of what county VA would be, but there's a criminal threat. There's a criminal damage to property 2013 and interference with law enforcement, criminal damage to property again, criminal threat. It's on your record, ma'am. You can talk to your attorney about it. But these are all matters and they keep going. There's how
far back do you guys, use that against a person. I thought it was like 7 years.
I don't know where you heard it 7 years that I can't use anything you've done after 7 years, criminally speaking, but I have never heard that law. They didn't teach me that in my law school. Maybe they did in yours, but not in mine.
I was
Ma'am,
just asking a question. You don't
I'm
be rude.
going to
I was
answer
asking
your
a question.
If you will let me, I'm really trying to stay calm and not find you in contempt. But the way you are sassing and disrespecting and arguing with the court puts you in a position where I could find you in contempt, order you to pay a fine, and actually order you to serve jail time. I don't know if you're aware of that from this long history, but let me tell you this. Your history, I can consider your criminal history as far back as you started committing criminal history and establishing it. Yeah.
Oh, I didn't know that. I didn't know that. I'm sorry.
Well, I'm sorry you didn't, but now you do know that when you started establishing a criminal history, it became a basis that future courts could look at to determine whether or not you're a risk to come back to court, whether or not you are at risk to the community to keep violating the law. And that is why I'm going through this record. I probably wouldn't have scrutinized it as much other than you've challenged me, you've questioned me. And so that's what I'm looking at. And I think it's very reasonable that the state recommended, and they've got more traffic matters, it sounds like, than I do I'm just looking at your Odyssey state record that's through the state computer system. He has the whole official KBI, FBI records that I don't have. And from what he said, he has more than I do. And yet he has restrained himself to recommend only a $3,500 OR bond. And because he recommended that before, but turn off whatever it is you're causing feedback, whatever you're recording me on. Because
I'm not recording you on anything, ma'am.
I have a very busy docket, ma'am. I really need to get on. This isn't fair to the other people that are politely waiting their turn.
Okay, but why did you accuse me of recording you? Because I'm not recording you at all.
You turned on a TV, you turned on a computer.
I don't have a TV in my home. I don't have a TV in my home. Would you like to? I don't. I really didn't turn anything on. I'm sitting right here and I don't have a TV. I don't own one.
Ma'am, you started causing feedback. Your recording device started causing feedback. And that is usually because someone turns on another device. All right, miss, I have got to get on with that. Would you just stop and listen to me?
Yeah, but I didn't do anything like you're accusing me of. I really didn't. Okay,
one more response like that, and you're going to be found in contempt, and I'm going to issue a citation to have you picked up and put in jail. Please.
Oh, please, please. I hope it happens. I haven't seen this yet.
Do not force me to do that. I don't have time to do the paperwork to do that today. You can see this docket. I've got a full afternoon docket, and I want to give everyone their due rights today and their due hearing. All right. Now, your bond is set. No arguments allowed at this point. $3,500 OR. You will go into a breakout room as soon as this hearing is over. There will be an invitation to a breakout room flash on your screen. You will go into the breakout room with court security too. They will set up a time with you to go out to the jail and take care of your picture, your prints, and post that OR bond. You do not have to take the money with you, but you have to sign a document that if you don't come to court and do what you're supposed to on that bond, you can forfeit that bond, causing the money to end up in the state's hands, and you can cause a warrant to be issued for your arrest. So that is your bond. And tell me again, Jenna, her next court date.
Your Honor, I have January 12th at 8 a.m.
You must come back January 12th, 2026 at 8 a.m. with your attorney and ready to proceed. Mr. Regier, is there anything else I need to address?
No, Your Honor.
All right, Ms. Naxted, Ms. Johnson. Ms. Johnson, anything else you want to take up before I let you go?
No, Your Honor.
All right, then I suggest you call Darren Patterson, your court-appointed attorney, and let him know what's gone on today.
I will. Thank you.
You're welcome. And put your face back on your screen. Where did you go?
I'm right here.
All right. And next time I see you, next time you see any judge, and you've seen a lot of them over the years from this record, next time you see any judge, you need to show the judicial process a better appearance, a better kindness, a better courtesy than what I've seen today. Maybe you think it's courteous, but it's not, trust me. All right, you may go at this time, Ms. Johnson. You are excused from today's proceedings. Continued on that bond.
Your Honor, does she have to be in a breakout room before she goes on?
Yes, she does, please. Ms. Johnson, no, you're leaving me, but you're not leaving the recordings. Go see the court security officer. Thank you, Jenna. All right, well, where do we begin? Mr. Mannion, I'm going to take up your case.
Oh, that was good stuff. That was good stuff. It would have been better if it ended with a remote tase. That's what I was pulling for. I wanted a little arc coming right out of her device and stinging her in the face. We have the technology. We can do it. We can do it, people. Let's get it going. All right. All right. Good stuff. Thank y'all. Thank y'all for coming on. I appreciate it. I'll see you soon.